The last thing that we want when we work hard to create something is for it to be broken. And the same is true with your trust and estate plan. You've put all that time, effort, energy, and money into creating a solid trust and estate plan in the past. And you want to ensure that that peace of mind you have is not a false sense of security, and that your outcomes for when life happens are going to be carried out the way that you want and that you put together in your planning. So what you need to do is to periodically review your trust and the rest of your estate plan to ensure that it still incorporates your values, it still is going to result in the outcomes you want, and still consistent with the changes and updates in the law over time, because things are certain. Changes in relationships, changes in your life circumstances, your health, your finances, and changes in the law. So death, taxes, and change are certainties in life. And what can happen if that's not being observed and monitored is that you can go from having a good plan to having a broken plan. And as I tell clients, having no plan is a bad plan, but having a bad plan is like having no plan. So we work hard to encourage our clients and all of you to stay updated on your planning and to review it. And in light of that, I want to share with you some important points that you can take away, that you can take back to your own plan, take a look and see and apply and see if there's anything that's broken, because you really need to stress test your plan periodically, as I mentioned. So here are the things that I like you to think about when you're taking a look at your plan to see if you have a broken trust or a broken estate plan. And if you do, then it's definitely something that you want to take care of. But here are the things to think about. The first thing is to sit down and think about the life circumstances that were going on at the time that you made your plan. Your plan is going to be related to what was going on then and what you could foresee at that point in the future. So you were making plans within the bubble of time. Now, in a new period of time down that road of life, things have changed. So just take a stock in what's changed, because it might affect how your planning and your trust is set up. For example, if there's been births or deaths of individuals that you've provided for in your planning, or maybe you've designated as a trustee or other decision maker, they're no longer alive or no longer capable because of age or illness or infirmity, then those are things that you're going to need to consider. Because if your plan went into effect today, your plan is designating those individuals as beneficiaries, and maybe not including others. I had new clients recently that they did their planning years ago after they had their first child, and they hadn't included any of their other children into their planning, which would create obviously an unintended result of bypassing two of the three of their kids. So that's an example of just how you would want to take a look at and take stock in your life circumstances. Also look at the assets you've acquired or you've sold, no longer have, or they're new in your life. That's all going to be very important. Looking at your beneficiaries themselves. Your beneficiaries may have changed over time, and what you want to provide for them may be different as a result. Maybe they were young and they were minors when you first created your planning, but now they're adults. You have a clearer picture of who they are, and as a result of that, there may be some updates to the planning that you have that you want to do. For example, perhaps you have allotted for them to receive an outright inheritance at a certain age, and they've already eclipsed that age, and you don't want them necessarily to, if you've passed away, to just receive a lump sum now. So maybe you want to update some of the conditions in your trust for when beneficiaries inherit. You want to consider if you provided enough protections for those beneficiaries within your planning. Maybe they have some lifestyle changes of their own. They've gotten married, they have their own children, and you have grandchildren now, and you want to consider that. Maybe they are struggling with something in their life, and that wasn't considered before. Maybe there are additional planning techniques where you can provide a force field around their inheritance without keeping it from them. So adding in creditor protections might be something that you could take a look at. When it comes to your beneficiaries, how they've changed over time will be important to consider with your planning. In addition, your beneficiary designations that you have included in life insurance, retirement accounts, for example, even bank accounts, you're going to want to make sure that they align with how your trust is operating. uh, because your trust isn't just working within itself. There might be these other accounts on the outside. And that brings me to the third point. You want to look at your asset ownership. The asset ownership, it could be impactful to your trust from a standpoint of you've identified specific things that you owned and assets that you owned that you were making gifts to people when you first created your trust, but you no longer have those items. So that would be a point that you would want to update. Maybe you acquired new assets such as new real estate, vacation home. You've opened a business. These are all things that need to be incorporated within your trust that may not have been considered because they impact um, how the transition of assets to your beneficiaries, your spouse, and if they're not considered within your planning, then they could lead to an unintended result. In addition to um, looking at your changes in your beneficiaries' lives, changes on the assets that you have, you're also going to want to look at who's running the show, right? These are your trustees. These are what we call your decision makers, your trustees, the executors of your will. In California, we call them personal representatives, to your healthcare agents, to your powers of attorney. These individuals that you've given agency to act on your behalf when you no longer can due to incapacity or death, are they still good candidates, or have something happened in their life? Is there a life circumstance that maybe they've aged, they have an illness, or in some cases we have clients that now the people that they chose in that time in their life, it was it would have worked fine, but now that they have a new job that really would not make it feasible for them to serve as a trustee, or they've gotten married and now have a number of children of their own, and it's just not feasible for them to be the trustee in that situation, or somebody's retired from being a working professional and then you've designated them as a trustee. Maybe you have designated co-trustees or more than two or more co-trustees, and how it's actually going to play out might not be a great idea. And taking a look at, certainly in those situations, we want to have more of a conversation of how that plays out. So the identity of your trustees, whether they're capable, they're available, if they're going to work well with your beneficiaries now and this point in time, is definitely something to consider. And the fourth aspect is looking at whether there's been any significant legal changes across the board that impact your plan. And there's been a number over the years, there always is, so it depends on when you created your plan. A number of trusts that I review often are set up, these are older trusts that are 10 plus years older. They've utilized an outdated tax strategy called AB trust planning. And when we apply that trust planning to the current circumstances of the laws now, and we play that trust out, oftentimes it leads to unintended results where a spouse is restricted from assets to a greater degree than we would have wanted. It could create some adverse tax consequences when it comes to capital gains taxes to our children, which was not intended at the time. And it creates a lot of unnecessary complications. So looking at the type of strategy that was put together for your planning might not be appropriate. Conversely, maybe you started off with a very basic trust, and now your life and your wealth has grown, your life has changed, and you might need some different options. Particularly true if you are now on a second or subsequent marriage. There's different types of planning for that. If you have assets that are appreciating, there's different type of tax strategies we can look at. We have to balance out potentially the estate tax. So things that you didn't have before, you might need now. If you're concerned about lawsuits and getting sued due to a profession, maybe you are renting property out. Those are all factors that you might not have considered in your plan before that you're going to want to incorporate. Looking at your financial power of attorneys and looking at the date in which you sign those documents is going to be significant, because a lot of financial institutions have been imposing new rules, at least policies, that aren't laws, but they're internal policies as far as the staleness on the date in which those documents are signed. So some are as early as 18 months. If a power of attorney is older than 18 months, then the financial institution is not going to recognize it. And this is a result of just the barrage of fraud over the years. And banks and financial institutions are being very sensitive and concerned about getting sued if they followed an outdated power of attorney that is no longer valid, for example. So, and in addition, a lot of power of attorneys that were established many years ago are missing a number of important provisions that the current, in today's current power of attorney has that will help your attorney, in fact, be able to actually operate on your behalf. If it's not in the power of attorney document, then a financial institution or another institution could say, you know what, you don't have the power or authority to do that. So we want to make sure that we have a comprehensive enhanced power of attorney. Some of the older, more basic power of attorneys really fall flat in implementation. Looking at your plan and determining whether your estate plan is broken also involves taking a look at your healthcare decisions and making sure there's still an alignment of what you want, and making sure that your healthcare advocates are still the people that you would want. Again, just like your trustees, are they still capable? Are they still perhaps more local to you? Do you still have a relationship with them? And you might think it's odd, but sometimes we forget who we put in that power, and then we take a look at our healthcare directives. It's staring there right at us in the face, and so we can see that, oh, gee, that relationship isn't good anymore. There's also opportunities to include new directives because your intentions of outcomes may have changed over time. There's new things to consider. Especially after COVID, new types of procedures that you may want to incorporate into your planning that weren't there to provide some more specificity in your directive planning. Looking at some new developments when it comes to just technology in general, as an example, things change. Do your plans, do your trusts, do your power of attorney documents include the aspect of digital assets? What digital assets do you have? How are those incorporated into your trust and your planning? For example, email accounts, online accounts, social media accounts, data. How is that actually incorporated? Other technology like cryptocurrency. How is that incorporated into your planning? Does your plan account for that? And lastly, we want to look at if you've provided for other charities, or maybe you have pets in your planning. These sometimes are things that change over time that we want to look to see if we're still in alignment with the charitable giving that we have, if we provided for pets in a certain way, or maybe we didn't. If we have pets, we want to make sure that those are included in our planning as well, that we've designated caretakers for our pets. Sadly, what can happen is that if pets are not considered, they're overlooked in the planning, and they aren't cared for in the way that we would have hoped. So there's many other things that we can talk about when it comes to your planning and whether or not your trust is broken. I wanted to highlight a few things just to give you a flavor of what's out there. What I'd recommend is you speak with a professional, like an estate planning attorney like myself, or, to be able to have a sit-down conversation, really take a look under the hood of your planning to see what's actually there, and have somebody explain it to you. Oftentimes when I meet with new clients, when I'm reviewing trusts that they put together before, one of the first things they mention is, we didn't know that that's what it said. Because maybe it was never explained, or maybe it's just been a long time. Either way, it's important for you to understand exactly how your trust and planning is going to operate. So sit down with an estate planning attorney to have that explained to you, and then compare it with your intentions now, your life circumstances now, and the attorney can explain to you what changes in the law have now been impacting your planning. Do yourself a favor. Don't sit and assume that your trust is not broken. Have it checked out. And if you'd like an opportunity to do that, of course, we're here to help you. And if you'd like to know more information about some of the other topics that I talked about today, check out our YouTube channel and our social media channel. We're always happy to give out lots of valuable, good information. And if we can further assist you, it would be a privilege. Thanks so much. Continue to be amazing.